All right, Mr. Clark.
Good morning. Thank you, Your Honor. May it please the Court. My name is Christopher Clark on behalf of the appellant, Nick Rhoades. This appeal raises two independent but related reasons to set aside Mr. Rhoades' conviction. One relates to the constitutionally inadequate plea colloquy conducted by the criminal trial court, and the other relates to the lack of a factual basis for convicting Mr. Rhoades of the crime. I will start with the issue concerning the lack of a factual basis. The appellate court incorrectly affirmed the conviction of Mr. Rhoades based on its conclusion that an act of oral sex was sufficient to provide a factual basis for a guilty plea under Chapter 709C1. The court reached that conclusion despite the fact that Mr. Rhoades did not ejaculate during oral sex and despite the fact that Mr. Rhoades had an undetectable viral load. These facts negate critical elements of the statute. With no ejaculation and an undetectable viral load, there was simply no exposure of an infectious bodily fluid to the alleged victim and no act that could have resulted in the transmission of HIV. Indeed, the record...
Wasn't the testimony that it was not impossible to transmit the virus? And what does could mean? I mean, that's my problem.
I think there's confusion by the appellate court with respect to the testimony. Because when scientists and medical experts and the expert that was presented in this case talk about whether acts could result in the transmission of HIV, they often have two inquiries. Is something possible? And two, if it is possible, what is the likelihood of transmission? And I submit that the appellate court took answers to the second question and sort of applied them to the first. So the testimony with respect to, under these facts, was HIV transmission possible? The testimony was likely impossible. The risk was likely zero. So we have a set of circumstances where the testimony is suggesting that, in fact, the transmission of HIV was likely not possible, and so therefore the could result in the transmission of HIV portion of the statute is not satisfied under these facts. And the amicus brief that was submitted agrees with that conclusion. And just to highlight what was said there, the risk of transmission through oral sex with an HIV-positive individual with no measurable viral load is, quote, likely zero. And in support of that statement, they direct the court's attention to a 2000 study of over 400 serodiscordant couples with no measurable viral load in which there were no instances of HIV transmission. And then they cite to a 2008 consensus statement by 4 HIV experts stating that an HIV-positive person with an antiretroviral therapy that results in the undetectable viral load is not sexually infectious, i.e. he or she cannot transmit HIV through sexual contact. Now, the appellate court had relied on some of the precedent of this court, in which the court took judicial notice of certain ways in which HIV could or could not be transmitted. And, you know, I think under the facts of this case, we would ask this court to reconsider those findings, at least as they are applied.
How would the counsel be ineffective if she's relying on established case law? I mean, we have to show ineffective assistance to counsel. Everything you say may be true, but how does trial counsel become ineffective if there's case law that exists out there that says otherwise, interpreting the statute?
Well, the case law interpreting the statute was certainly interpreting different factual circumstances, number one. So in the Stevens case, for example, where we get the principle that oral sex could result in the transmission of HIV, and there's judicial notice taken of that fact, that was a case in which there was ejaculation. And then we have the other case in which the principle of ejaculation is irrelevant, which I submit is really pushing the language of the statute, which does require the exposure of a bodily fluid. But even there, you have that in the context of vaginal intercourse, in which there is a very different type of risk assessment with respect to the transmission of HIV. So number one, there is a strong argument that those prior precedent don't apply to the facts of this case, and this case is factually distinguishable. But the conclusions and evidence of the expert and the amici that are submitted in this case were certainly available to counsel at the time. And I think what we have here is a counsel that really showed, the record shows had a really quite, sort of lack of understanding of HIV transmission and how that would apply to this law. So for example, there's no evidence that he spoke to Mr. Rhoades' physician or any HIV expert prior to the entry of the guilty plea, and in fact testified at the post-conviction proceeding that Mr. Rhoades' counsel testified that in fact he thought the contact between a hand and a penis would result in a triable issue of fact for a jury, which again is ridiculous in light of what we know scientifically about what is going on with HIV. So I don't...
Didn't he present some of this evidence, though, at the sentencing hearing?
At the sentencing hearing, yes.
Yeah, so he had to prepare for the sentencing hearing, or at least knew what would happen. I mean, was he supposed to withdraw his plea then, or what's going on?
I believe that the record shows that Mr. Rhoades' counsel did not speak to Mr. Rhoades' physician until the day of the sentencing hearing, so I'm not sure that there was any preparation that went into that testimony or any attempt to
Well, I thought the
understand.
record reflected that he had, in fact, been in contact with many of his doctors at the University of Iowa prior to the time of the plea proceedings, even.
I don't think there's any evidence in the record to suggest that counsel for Mr. Rhoades discussed the issues that we're raising with the court today about how HIV is and is not transmitted. And to the extent that, so the statute only criminalizes exposures of bodily fluid that could result in the transmission of HIV, an inquiry that has as its very nature sort of a scientific or medical foundation.
Let me ask you a question that I think you're touching upon. As I read the Court of Appeals as opposed to what happened in the district court, it seems like there's maybe a disconnect. The Court of Appeals relies on the judicial notice in Stevens and Keene to draw the conclusion that there's a factual basis. On the other hand, the district court seemed to rely on what Mr. Metcalf talked about, that I understood there was a possibility of transmission, although it's not clear, as you say, where he got that understanding from. What do we make of that? I mean, the Court of Appeals relies on case law, the district court relies on maybe a reading of the factual record.
Well, it's a reading of it's a reliance upon Mr. Metcalf's claim that there was perhaps his understanding that there was an exposure here. And what we're submitting is that sort of facts that this court could take judicial notice of is that this factual scenario creates serious questions as to whether there's any factual basis at all. And so if you have something that inherently requires sort of a medical scientific understanding of a somewhat complex nature, we would submit that that may not be appropriate for sort of sweeping statements of judicial notice that would be applied to all factual circumstances. And to the extent that the court were to take judicial notice of how HIV is and is not transmitted, certainly we have the studies that are referenced by the amicus brief. And just this past week, there has been yet another report released in a conference on retroviruses where there was a study, again, of both heterosexual and homosexual couples in which one of them is HIV positive.
Let me kind of frame it a little differently. I mean, if Mr. Metcalf had testified that I relied on the Keene and the Stevens cases, and I figured that based on those I didn't really have a defense, and therefore I encouraged my client to plead guilty. That might be one situation. That isn't what he testified. Instead, he said, I thought there was a possibility of transmission, although he doesn't, again, explain why. Is it your position that if he really didn't investigate scientifically whether there was a possibility of transmission or talk to the doctors treating your client, that in that case he did commit ineffective assistance?
It is certainly our position that he had a lack of understanding about basic HIV transmission 101 that calls into question his ability and the counsel that he gave to Mr. Rhoades with respect to the application of prior precedent to the facts of this case. I do think we have in the appellate court a sort of direct application of prior precedent in a way that we would suggest is not appropriate to the facts of this case. And I think the appellate court blipped over the suggestion that the undetectable viral load really affects the way in which HIV can or cannot be transmitted. And I should say, yeah, an undetectable viral load it sort of depends, it's roughly around 50 copies of virus per milliliter of blood. And just to give the court a sense of the order of magnitude of what that means, is that an HIV positive person who is untreated and is highly infectious may have over 1 million copies of virus per milliliter in their blood. So we're talking about therapy that severely suppresses the level of virus, so much so that the studies, and the one that I was referencing that came out last week, are showing over thousands and thousands of sexual contacts between serodiscordant couples in which they are having condom-less sex. With ejaculation resulted in 0 infections because the viral load is so low.
Can I change the subject for a section? As I read the transcript, there was a letter from your client to Mr. Metcalf saying, "Can you get me a plea?" I mean, some correspondence in that. How does that affect your ineffective since it's a counsel case?
Well, I think it also must be viewed in light of the testimony that suggests that what Mr. Metcalf was telling Mr. Rhoades, that in light of the county in which we're located, which according to Mr. Metcalf, there was no possibility of getting a fair trial, he was suggesting to Mr. Rhoades that was, again, the only avenue that he might have. That, supplemented with the fact that he did not have a basic understanding of HIV was and was not transmitted. And
what does the record show about the paying for this defense? I mean, what was going on here? Was Mr. Metcalf, I got some indication Mr. Metcalf was ready to quit. I mean, is any of that in here, or am I just reading that into the record? I believe the record shows that Mr. Rhoades and his family in particular were paying Mr. Metcalf for his services. And so I don't think there's a question that he was not being paid, if that's the question that you're asking. That letter, Mr. Metcalf talked about, I know you need to be paid, you need to do this, my dad's not paying anymore, blah, 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 blah. And then he says, what about a plea? I mean, what do you make of that? I make of it that Mr. Metcalf was not providing Mr. Rhoades with effective counsel with respect to what his options were. Again, it was the duty of his attorney to investigate the facts of the case, and I think investigating the facts of a case in these circumstances does require you to educate yourself about how HIV is and is not transmitted. And I think the clear evidence on the record is that Mr. Metcalf did not do that and was not therefore advising Mr. Rhoades effectively. So if there was a discussion, even if initiated by the client, as to what a plea was, there's certainly an obligation of counsel to come back and say, well, let's discuss whether in fact there is a factual basis for such a plea. Mr. Metcalf was working with some layperson at the University of Iowa, maybe a nurse even. What was that all about? I mean, because as I understand it, there was like a 2-month delay between him even being brought to Waterloo for the charges. He was in the University of Iowa hospitals. I mean, what was that? What were those conversations about if they weren't about HIV?
Well, there was a period of time after the arrest in which Mr. Rhoades was being treated for a variety of mental health-related ailments, and so there was a period of time in which I think the focus was on getting Mr. Rhoades in a state of health that would allow him to effectively participate in his own defense. And so, I think that's what was going on sort of in the immediate aftermath of the arrest. The second issue raised by our appeal is the issue of the plea colloquy, which was not effectively addressed by the intermediate appellate court, and we would ask this court to consider that. The law is pretty straightforward, we believe, that before accepting a guilty plea, a criminal trial judge needs to address the defendant, inform the defendant of the charges, and make sure that the defendant understands the nature of the crime and the elements of the crime. And that duty is heightened when there is a mens rea element in the crime. And here there is, what is a crime is the intentional exposure of a bodily fluid to somebody else in a manner that could result in the transmission of HIV. And that state of mind element of the crime, intentional exposure, is embedded in a defined term in the statute, intimate contact. And so when this guilty plea was accepted by the criminal trial court simply asked Mr. Rhoades if he had engaged in intimate contact. Now, of course, intimate contact has a colloquial meaning that is very different than the meaning in the statute. Kissing or holding hands may, to many, be considered to be intimate contact, but it is not, those things are not, of course, the intentional exposure of bodily fluid to somebody else in a way that could result in the transmission of this disease. And we believe that that is an error. That is a violation of the constitutional requirement to conduct a plea colloquy. And Mr. Rhoades' counsel provided ineffective assistance by allowing that plea colloquy to take place. And that we cite two cases for that proposition, that in fact allowing a trial court to proceed with an inadequate plea colloquy is in fact ineffective assistance of counsel. And it relates to putting on the record the factual basis for the crime. And of course, a claim of ineffective assistance of counsel that is based on the lack of a factual basis in the record, there's no prejudice required as a result of that. Prejudice is inherent in that sort of violation. And so we do believe that as a result of that inadequate plea colloquy, the conviction needs to at least be set aside so that Mr. Rhoades has the option of determining whether he would like to plead guilty. And I believe my time is up.
Thank you, counsel. Mr. Smelik.
May it please the court. Since I picked this case up months ago, I've heard nothing but the lament that this man had been sent to prison for 25 years for nothing other than a protected consensual act of sex with a willing participant. The problem with that refrain is that it is at best misleading and at worst completely false. There is not in this case an assertion that there was one sexual act that was protected committed in this case. In fact, the testimony at the PCR established that there were two unprotected sexual acts, 2 acts of oral sex, and that finally the one act that was protected was not an effectively protected sexual act. In fact, according to the CDC's website, the best way to reduce the risk but not eliminate the risk of transmission of the infection is by the use and the correct use of a condom. There are 2 reasons in this case why it was not a correct use of a condom. Therefore, by the CDC's definition, not an effective means to prevent transmission. And that is that 1, you have to be able to maintain an erection to correctly use a condom. And secondly, you have to withdraw immediately upon ejaculation. That didn't happen in either instance here. We have the defendant's own testimony that he had a sexual dysfunction, and we have Adam Plendel's testimony that that the withdrawal did not occur as soon as ejaculation finished, and the condom came off inside of him. So effectively, there were no protected sex acts in this case. And I would submit to the court under those facts, this is just Keene, and this is just Stevens.
In the statute defining intimate contact, what does the words "in a manner," mean?
What this court has said is in a manner means the type of act which has been found to be a possible transmitter of the virus. And what you said was we can take judicial notice that sexual intercourse is one of those ways. You said in Stevens that oral sex is another one of those ways in which the virus can be transmitted. It's kind of an objective standard I would submit to the court. We can look.
But those were judicial notice of facts, weren't they, in all those cases, and not judicial notice of law?
Well, I think they're both. I think they're a recognition of the facts in that particular case and whether those facts as a matter of law established that element of the crime.
At that time?
At that time. Well,
judicial notice of facts change. I've found cases where we've taken judicial notice that Hong Kong is a British colony. I don't think that exists today anymore.
But I would submit to you the facts haven't changed from Keene and Stevens to the present. Even the expert in this case testified that it is not impossible to transmit the virus. The CDC's website says it's not impossible with an undetectable viral load to transmit the virus.
But if
Well,
the
does the evolving science make our pronouncements in our HIV pronouncements in Keene too broad? for
I don't think
today's-
that,
Well, for what we know today?
I don't think the science has evolved as much as is suggested. Certainly, the CDC doesn't say that it is impossible. And remember, this is a low standard. This is possibility, not improbability, not significant likelihood. It's whether or not it is possible. And even the defendant's expert in this case testified that it is possible that the virus can be transmitted with a low viral load and with the type of sex that was practiced here. Is it less likely? I think everyone agrees that it's less likely. But the question is about the possibility, not the likelihood.
Here's the question I have. I mean, if we put Keene and Stevens aside, following up on Justice Wiggins' point that they're really judicial notice of facts, and therefore they're not like normal precedents that you can just follow in interpreting a statute. They were judicial notice of facts for those particular cases. Then we're left with, and also based on the fact that it doesn't look like Mr. Metcalf relied on those cases in advising or his client, then we're left with Mr. Metcalf's testimony that there was a possibility of transmission, and what I don't follow is what investigation he did to come to that conclusion. And before you conclude that wasn't a viable defense, wouldn't you have to do some investigation?
Well, I don't know that the record is really adequate to tell us how much of an investigation he did and what specifically he reviewed to come to the conclusions, just because the right questions weren't asked. But I find a fair inference from the testimony that I read from Mr. Metcalf that he had done extensive investigation prior to this case. As it's been suggested, he's talked to the nurse that treated Nick Rhoades many, many times. And she has some knowledge. I think he testified she was knowledgeable about HIV. He testified that he talked to Nick Rhoades, and that Nick Rhoades was knowledgeable about HIV. You add to that, and again, I don't know that he didn't look at Keene, and I don't know that he didn't look at Stevens. They were certainly in existence at the time.
I agree. As I read the transcript, there's a lot of very leading questions from the assistant county attorney, and then there's some areas that just aren't followed up on by defense counsel, so it's sometimes hard to know what he did and didn't actually know.
So I think it's also true, though, again, and I would submit to the court, the facts in this case aren't different from Stevens. They aren't different from Keene. The defendant makes the argument in this case that he didn't ejaculate. Where in the record is that supported? The testimony of Adam Plendle is that he did. Adam Plendle testified that he tasted salty semen in his mouth. So there was ejaculation in this case. And further, if not ejaculation, at least the transmission of a bodily fluid.
Let me ask this question. The statute requires intentionally doing it in a manner that could possibly do it. If the science is such that the type of sex Mr. Rhoades had arguably could say that it's not the manner in which it could be transmitted, or at least Mr. Rhoades didn't understand it's the manner it could be translated because of low viral load, using condoms, things like that. I mean, don't you think that that's an important consideration in deciding whether or not Mr. Metcalf did an adequate investigation into what happened that day, even if the condom fell off? I mean, you may attempt to do it in a manner, you know, not purposely doing it. He didn't purposely pull the condom off, I don't think. That was a testimony. And if the viral load's so low that you can't get an oral sex unless there's an open sore, I mean, how do you get the factual basis that he intentionally did it in a manner that could?
Because I don't think there's any science that says it's impossible to transmit the virus in that way. There's science that says it's less likely. There's science that says it's highly improbable. But
then you're making the statute strict liability. You have sex and don't disclose, you're liable. And if that was the intent of the statute, why didn't they just say, if you have sex without disclosing, you're liable, rather than making an affirmative defense? And by making an affirmative defense, it seems to me there at least has to be some way not to violate that statute without giving consent. And that's what's bothering me.
Well, again, I think could, as this court has said, means possible, and all the science is that it's possible. And in fact, the CDC says it is possible. So I don't think it creates a strict liability statute in that sense.
Let me give you a hypothetical. I used to represent blood banks. If you go and donate blood, you know you're HIV positive, you have a very low viral load. The tests are extremely precise nowadays, but there's maybe a 1 in a million chance that it could get through the testing and result in infecting another person. Have you then committed an offense under this statute?
I think the answer is yes. And I would go back to this is an informed consent statute. Let's think about that for a second. First, intentional in this case is not specific intent. We don't need to argue about what specific intent is and what general intent is. Intent is used in the statute, so it has to have a meaning. And this court has a long history of interpreting intent as it's used in this statute as knowledge. The defendant has knowledge that he's HIV positive, and the defendant has knowledge that he's having sex. That's what's required under this statute. It doesn't require that he intend to transmit the virus. It doesn't suggest that he intends to exchange fluids. Exposure doesn't mean transfer. Exposure doesn't mean transmit. It means create a risk. That's what's happened in this case.
But under those old cases, we used the judicial notice of fact to get us over the in the manner language. And we've never really discussed what in the manner means.
Well, I think, again, I would suggest that what you've said in those cases is in a manner means the type of sex in which it is possible to transmit the virus. This is one of those types. The judicial notice in this case would be no different than the judicial notice in those cases because the facts don't materially differ.
Let me just ask. I have actually two questions, but following up on what Justice Mansfield said, you know, the DNA context, for example, we have people who testify that, you know, the likelihood of a match is, you know, 1 million to 1. The numbers get to be really high. But if you ask that expert, is it possible? Is it possible that you're not right? Those experts would say, well, it's possible, but not likely at all, basically. Science is such that nobody talks about terms of impossibility. You get scientific results that are persuasive, that are even overwhelming. The science doesn't usually talk in terms of absolute impossibility. And so this is troubling me a bit as we're talking about the statute. I understand the language, and I do understand the force of your point. On the other hand, as Justice Wiggins says, it's really not a strict liability statute. Doesn't the notion of impossibility have to have some kind of, kind of pragmatic feature rather than theoretic impossibility? I'll leave it there for now.
I think that depends upon what the legislature intended. They could have used a significant risk. They could have used highly likely. They could have used highly improbable. They didn't use any of those terms. They used could, and this court has said could means possible. Do we like the fact that an expert would not come in and say it's impossible? No, but I would submit that that's a reason to go back to the legislature and impress upon them the need to change the statute, not to reinterpret the statute to find counsel ineffective under these particular circumstances.
I certainly agree with that point. But again, following up on this hypothetical, the person who knows they're HIV positive donates blood, the donation is intercepted like it would be 900, 9,000, whatever, almost every time, 1 out of 1 million chance it gets through. And that person has committed a felony under the statute subject to a 25-year sentence.
Well, no, because I don't think he's had intimate contact with anybody.
I'm not sure about
There's
that.
another statute.
Intimate contact is intentional exposure of the body of one person to a bodily fluid of another. When you donate blood, you know that's going to go into someone else's body.
I don't think that's what's intended by the statute, but if that's what you think the circumstance is, then I guess it is a violation of the statute. And again, go back to the legislature and say, is this really what you intended? But that doesn't mean there isn't a factual basis in the facts of this particular case. That extreme example may be a reason why, in that particular instance, we didn't want to prosecute him, but not under the facts of this case. Again, I want to go back to this idea about this act being consensual. The statute requires for you to avoid prosecution in this instance when you're going to engage in these type of sexual acts is that you disclose your condition. There was no disclosure at all in this instance. There was, in fact, affirmative misrepresentation, not on one, but two occasions. You can't have consent under the statute without disclosure. So there's not a consensual act in this case, and it's improper to characterize it as consensual under the terms of the statute itself.
Can you give me an example of how a person with HIV can have sex with somebody and not violate the statute without the disclosure?
No, I think disclosure is required.
So it's a strict liability if you have HIV and have some kind of sex with somebody, whether protected or not, because the condom may fall off or there's a 1 in a quadrillion billion chance you violate the statute.
This court has said that the term intentional that requires general intent is not a strict liability crime. He has to have knowledge of his condition, and he has to engage in the act.
Why
Why
did the legislature make disclosure an affirmative defense why didn't they just make it part of the crime, having sex with failure to disclose? I mean, why did they do that? Why did they separate it out as an affirmative defense? If it's the only defense and it's the only way not to commit the crime.
I suppose that, and I can't, speak for the legislature entirely, but I think that there is an acknowledgement that if at some point somebody says you cannot transmit the virus this way, then you need the affirmative defense. But until an expert says you cannot transmit the virus this way, it's appropriate to have it as an affirmative defense rather than as an element of the crime itself. And I think that that's an appropriate way to deal with these particular circumstances. I would like to just say one thing about the ineffective assistance of counsel, if I may. I see my time is up. And that is that, remember, this is Hill versus Lockhart. This isn't a case where there's been a motion and arrest of judgment that's challenged the colloquy itself. A factual basis challenge has presumed prejudice. When you're talking about voluntariness, you're talking about Hill, and there needs to be prejudice. That's not established in this record. Thank you.
Thank you as well, counsel. Mr. Clark, rebuttal?
Thank you, Your Honor. There's been some comments made about sort of the role of the legislature and a suggestion that our interpretation is not consistent with the plain words of the statute. But what I heard counsel just say is that what this statute basically criminalizes is any and all sexual act between HIV-positive individuals, and that is absolutely not what this statute says. What this statute makes a crime is the intentional exposure of a bodily fluid to someone else in a manner that could result in the transmission of HIV. The word intentional modifies the phrase bodily fluid. And so there needs to be an intent to expose one's bodily fluids. So that we would submit that ejaculation is certainly relevant, and the fact that a condom may or may not have fallen off during the act of anal intercourse does not affect the fact that a condom was used, which is highly indicative of this defendant's intent. The purpose of a condom is to not expose your partner to your bodily fluids. So I think that is probably the best evidence that we have in the record about the intent of the defendant.
How do you answer the Hill versus Lockhart argument about prejudice in this case? I mean, because you have to show that had this been done, he would not have pled guilty, and it has to be an objective standard, not a subjective standard. How do you get around that?
The difference between this case and the case that is cited by the state for that proposition, which I think was the Straw case that's cited in their resistance to the application for further review, is this case involves a plea colloquy about the fundamental factual basis for the charge. And so the claim of ineffective assistance of counsel as relates to the plea colloquy is about the lack of a factual basis.
Well, you also said, though, it wasn't voluntary, right? You had two challenges to the plea colloquy.
Correct, but the point is that when the judge conducted the colloquy and took what we would submit to be an impermissible shortcut, that the judge was not establishing on the record the factual basis for the crime, and most critically, the mens rea or intent element in particular. And that, we believe, is consistent with the line of cases that suggest when there is no factual basis shown that the prejudice is inherent.
But, so is it really, both arguments really boil down to factual basis?
I think that to some extent they do. There's sort of different shades of it. I think the plea colloquy relates to the sort of establishment of the factual basis on the record during that proceeding. And then I think the arguments that we make with respect to the application of this court's prior precedent to the facts of this case and whether in fact these are acts that could have resulted in the transmission of HIV, that is also that there is no factual basis at all for the charge, as opposed to putting it in the record.
I mean, I agree with you that intimate contact is sort of a term of art that in this statute has a different meaning than a layperson would normally attribute to it. However, Mr. Metcalf testified, and this wasn't challenged and it was accepted by the district court in its PCR ruling, that he explained the elements to Mr. Rhoades, what intimate contact meant.
And at best, the testimony is that he explained, is as you described, that he explained the elements. There's no testimony that he explained what intimate contact was and that it required the intentional exposure of a bodily fluid that could result in the transmission of HIV. And certainly there was the opportunity for him to have said that in the PCR hearing. He seemed to simply be mimicking that which happened in the plea colloquy, which we believe was ineffective. I did want to touch on the meaning of the word exposure, because counsel took the position that it does not require contact. And we would direct the court's attention to Iowa Public Health Code specifically addressing HIV, and that is section 141A.1. And it is the HIV section, and there is a definition of exposure. And the definition of exposure in that Iowa Public Health Code states that it is a specific contact with blood or other infectious bodily fluids. So we submit that that is the relevant definition of contact. And in fact, in this court's jurisprudence in Musser, there was a reference to that code and to the notion of transferring semen or contact with semen. So just sort of this general idea that any proximity of bodily fluid that would result from any sexual contact and therefore criminalize the sexual lives of all HIV-positive individuals, we believe is not at all consistent with the plain language of the statute. Disclosure is an affirmative defense in this statute, and it only comes into play if the state can actually put forward the factual basis for the charge. And we believe that the state cannot and could not do that in this case. No science that says it's impossible is the standard that we want, but that turns the burden of proof in a criminal setting on its head. It means that the state can come in with any theory it has whatsoever about HIV transmission, and it would be the burden of the defendant to come forward with a declarative statement from some sort of scientific authority that that is impossible. And I think the comments about how science talks about possibility are relevant here. The scientists are saying, in this case, with respect to the studies that we cite, and if this court were to explore judicial notice of what the current science is, you will find that what people are saying is that with this undetectable viral load and oral sex without ejaculation, it is likely impossible. So lack of possibility is the likely scenario here with respect to these facts, and we believe under those facts the state should not be able to proceed with a prosecution under this statute. I believe I'm out of time. Thank you.
Thank you as well, Mr. Clark. The case is submitted. We'll now take a 15-minute recess, no longer, and we'll pick up with the Smith case after the recess. We'll stand in recess.